New York City retirees celebrate a quick victory, but the city plans to rain on their parade. We'll interview the president of the New York City Retirees and their organization's attorney. I'm Mark Harrison, all that and more, as Labor This Week begins now. It was a nationally significant judicial victory, but it was fleeting, to say the least. On Friday, August the 11th, New York State Supreme Court Judge Lyle Frank issued a decision permanently prohibiting New York City Mayor Eric Adams from forcing the city's 250,000 retirees onto Aetna Corporation's Medicare Advantage plan, a move that would force retired union and non-union workers alike from their previously promised Medigap plans. However, within hours of Judge Frank's ruling, Mayor Adams and the city filed an appeal, sending the retirees back to court for yet another round of legal jousting. Joining us today to discuss the fleeting victory and the road ahead are Marianne Pizzatola. She is the president of the New York City Organization of Public Service Retirees and a frequent guest on our program, and Jake Gardner. He is the attorney who represents the retirees in court. He is a graduate of Stanford University and Yale Law and has extensive experience challenging unlawful government action, including several high-profile victories against New York City and state for violating the rights of active and retired municipal workers. Welcome to both of you. Marianne, I want to start with you. How was the victory received in New York?
It was received very well. Retirees were very excited to experience yet this new win, and it was a good day. Retirees were a little bit put at peace at mind that they knew that they could rely on the fact that they now still had their traditional Medicare and city supplemental health care plan. So it was very good for everyone.
Jake, it seemed like this came quicker than I thought it would, than a lot of us thought it would. Do you feel the same way?
I'm not very surprised that it came quickly. The judge was very well aware of the legal arguments and the factual circumstances. So there was no additional argument or papers for him to consider in the past month. He granted us a preliminary injunction back in July. So there was really nothing more for him to have to consider. So I'm not surprised that it came quickly, but it did come quicker than most judicial decisions I've seen.
And is that any indication that you have a stronger case than maybe if it took a longer time?
Yeah, I think there's no doubt that the court was not struggling with the decision. I think the fact that the decision came down so quickly is a clear indication that the court felt that our arguments were clearly meritorious and that the city's arguments were not.
And then, of course, it didn't take more than a couple of hours for the city to file an appeal. Marianne, how was that received by the folks in New York?
The news of the appeal?
Yes.
We were not shocked. Knowing that every time that we've had a win in court, the city turned around and either very quickly or within days appealed our case. So we were not shocked, although we were disappointed that they would continue to fight us, knowing that the judge, several courts have all affirmed the same decisions time and time again, and that Jake very adeptly was able to show that we would be harmed if we were all forced into one managed, privatized, for-profit Medicare Advantage plan, and yet the mayor still thought it was okay to try to force this through the court yet one more time on an appeal to force all of us into this plan.
Jake, will you be handling the appeal?
Yes, I will be.
Can you explain to the folks that are watching exactly, can you sort of take us through step by step how this is going to shake out, what's involved?
Sure. So the next step is the city will eventually file their opening appeal brief, which is just a document that says why they're right and why we're wrong. They will also include all of the documents submitted in the trial court. So that's called the record on appeal. We will then have a certain amount of time after they file their appeal brief to file our opposition, which is just saying why the city is wrong and why we are right. And then the city will have a certain amount of time after that to file their final brief. It's called their reply brief. That process takes anywhere from a couple months to a few months. After that, it's calendared for some time. The appellate court calendars it for oral argument a month or two later. And then after we argue it in court, it's only about, a total of about 10 minutes of oral argument in the appellate court. The court will issue a decision, and that decision could come, a week, or it could come, 10 months later. It's up to the court. So the next process is the parties will argue the issue in documents submitted to the court. We will have oral argument, and then the court will eventually issue a decision.
And will this be handled by the same judge?
No, this will be handled by a panel of appellate judges in what's called the First Department Appellate Division. So there are 5 judges who will decide whether the decision of the trial court was correct. And so if a majority of them rule in one way, that's the ruling of the appellate court.
And can you argue more than one point on appeal, or is it only one point?
You can argue as many points as you like, as long as you preserve those arguments, meaning you made those arguments before the trial court. So generally speaking, you can't make new arguments on appeal. There are some exceptions to that. But you're basically repeating the main arguments you made below. Now, lawyers are strategic about which arguments they want to focus on in appeal, because you have limited space and limited attention of the appellate court. But we understand, we expect the city to be arguing that everything that the court ruled below was wrong, and we'll argue why everything that the court ruled below was correct.
And is there a next step? Should one of the parties lose, can that then be sent up to the state Supreme Court, for example?
Yes, so it's possible that the New York's highest court, which is actually somewhat confusingly called the New York Court of Appeals, and the trial court is called the Supreme Court. So it's sort of the flip-flop of how federal courts work. It's possible that the Court of Appeals could agree to hear the case. It has certain jurisdiction where it has to hear cases in certain circumstances, and then it also has discretion to hear other cases. So it's relatively rare that the Court of Appeals will hear a case, just because there are so many cases, rising up through the trial courts to the appellate division. So they can't hear every case, but it's possible that the Court of Appeals could eventually decide to weigh in on this as well. And
then I'll ask you this, and I don't know if you can speak to it or not, but when right to work for public sector employees was enacted through the legislation, through the judicial process, through Illinois, and they almost ran that through to lose on purpose to get that worked up to the Supreme Court, the federal level. Is that remotely possible here?
I don't see any basis for a federal court to weigh in on this. There were none of our claims were based on federal law. There's no U.S. constitutional claim here. So I don't see this proceeding at all in federal court. This is going to stay in state court.
All right, I think that's good for everybody to be aware of, because people think of Supreme Court, they think of every fight goes there. But as you described for us, they get to choose what they're going to hear. And yes, I learned about that whole Supreme Court thing in New York by watching Law and Order when I was younger. That was very confusing initially. So Marianne's laughing because she learned the same way. Marianne, so you've got momentum here. This is going to be a long wait. It's a win. Are you sensing any fatigue? Are you going to be able to keep everybody as jazzed up as they have been?
I think the retirees are pretty excited that we've been this successful so far. And we've always known that litigation is never easy. We've always known that it's timely. It takes a lot of time, it takes a lot of effort, and it takes a lot of fundraising in order to keep meeting the benchmarks that have needed us. We've literally become a corporation at this point. We represent hundreds of thousands of people, and our business, this is literally a business. We become like AARP 2.0. We have several attorneys, and we have liaisons, and we have advisors, and we have accountants and bookkeepers, and we have so many people that are helping us with this, because this literally became this runaway freight train. We grew so big so fast, and the responsibilities upon all of us. We just thought we would get this done quickly, but this has morphed into a very large responsibility. And as Jake could tell you, and I'll call him all the time saying, I feel the burden of what we have to do, because if we don't do something right or something goes wrong, it affects lots of people's lives. This isn't just like a hiccup, like this affects their life. So is there fatigue in this? Yes, it is, because we don't understand that this is a morality. Where is the calmer, smarter people to say, well, we tried this, it really didn't work out the way we thought it would be. Let's go back to the drawing board and stop hurting these people. We're really putting a lot of pressure on them, anxiety and frustration, even to the point where the mayor says, well, the judge's decision is causing uncertainty and fear. No, it's you that's doing this. So you could stop this, but he's not. And I think that's also a frustration that the retirees have, is that no one is hitting the pause button to go, let's reevaluate this. Maybe this wasn't a great idea, because we're not going to stop. We know what we were promised. We know the difference of these plans, and we want to make sure that we're protected. So
they do keep fighting, and we hope you can keep the folks energized through the winter. It sounds like, Jake, we're talking about after the new year by the time we know where we are.
That's probably right. It's hard to predict for sure, but I don't think that's unreasonable to think that it'll come after January. It's possible it'll be earlier in the winter. But just to piggyback on what Marianne said, I mean, this has been a 2-year all-out assault on retiree healthcare rights by the city, and these retirees are fighting for their lives. So the fact that this has gone on for 2 years has really been a source of extreme stress and anxiety for these elderly and disabled retirees, and that stress and anxiety is itself causing all sorts of harm. So hopefully we can settle this, not actually settle, but we can put this to bed through this litigation sooner rather than later. But the city has made it clear that they are just going to fight this war relentlessly on their own retirees. So it's very disappointing and disheartening.
I know a judge has to rule on points of law, but sometimes in the world, the law is maybe slightly influenced by the public feeling. They say it's sort of an organic thing that grows. Does the fact that so many people come out, so many elderly people come out, they take the train to Washington, they show up in the park across the street from City Hall, is that having any kind of effect judicially, or is that only having effect on politically?
I don't think it's having any effect on the outcome of our litigation. This judge, and I think for the most part, all judges really try to focus on the merits of the litigation and not get distracted by anything outside the record. Obviously, judges are not living in a vacuum. They understand what's happening in the real world, but their duty is to focus on the arguments and the evidence submitted to them. So I don't think that really plays a factor in it. I do think the real world consequences, I think just, in our papers, we make clear the effect of this Medicare Advantage plan, what it would have on hundreds of thousands of elderly and disabled retirees. That, I'm sure, is having an effect on the courts, like any court's decision-making process. But that is different from, anything that's going on just, in the news or just, public opinion.
Maybe they're thinking about their own retirements and they don't want to be caught up in it. Finally, Jake, are you developing a precedent here legally that will be used on a national level as this thing becomes more and more national? Are you the first ones?
So we are definitely developing a playbook and probably a source of inspiration for other retirees around the country who are being forced into a Medicare Advantage plan. I should note that I also represented with co-counsel another group of retirees in Delaware, where we successfully fought the state's attempt to force about 30,000 state retirees into a Medicare Advantage plan. So Delaware and New York City, I think right now, are the two leading examples of how you can fight the government and fight for your healthcare rights. I hope that retirees around the country are realizing that if they band together, they too can protect their healthcare rights. Although not everyone is like Marianne Pizzatola. I mean, she has really, she's unique. It's not like, everyone can just wake up and say, okay, we're going to fight this and win. It is an enormous 24-hour-a-day, 365-day-a-year operation that Marianne, I can tell you, she's not getting any sleep. She's not thinking about much else. She is solely focused on protecting the healthcare rights of hundreds of thousands of elderly and disabled retirees and future retirees. So I hope that others will feel inspired, that if they come together, they can achieve something like what the New York City Organization of Public Service Retirees, Marianne's organization, has achieved. But I do think that it is difficult. If you're, a 70 or 80 or 90-year-old retiree, or if you're younger and you're disabled, it's you're dealing with all sorts of, issues in your life. How could you also take on this massive litigation battle to fight, your former governmental employer? Luckily, Marianne Pizzatola, did that. So hopefully we can, provide some inspiration or guidance to other retirees out there that it's possible, but it's going to take a lot of work.
Well, Jake, congratulations on a job really well done for these folks. And Marianne, I think Jake just said you get the last word.
Well, I'm grateful to have Jake and our other co-counsel, Steve, and Hannah from his office. It has been a ride, and I do hope that one day that this will, we will prevail fully, that protecting Medicare and retirees, and that retirees should always have the choice of whether they want to stay in traditional Medicare with a supplement or go into a Medicare Advantage plan. And yes, you're absolutely correct. This does have implications around the country. We want to make sure that we're able to show that if you put in that extra effort and you fight for what is right, make sure that you want to keep Medicare traditional around, make sure you protect the federal Medicare trust, that it's going to take a lot of effort. And it is. I mean, I'll be honest with you, we are tired, but we know what's at stake here, and we can't stop until it's done. So I think together, if the community can come together, we can get more public exposure to this, more public retirees and union workers around the country to say, look, enough is enough. Maybe we'll all be able to fight this together and be successful as one unit. So that's
there you
the mission.
Go home, rest up. The playoffs are beginning soon. Jake Gardner, Marianne Pizzatola, thank you both so much for being with us today. We're taking a late summer break, but like the song says, we'll see you in September. Until then, I'm Mark Harrison for Labor This Week.